How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Night, morning, wherever you're listening from. Oh, how's everyone doing today? Hope you guys are great. I've got some court. You guys want to watch some court? Got some good clips tonight. I know. I've always played good clips. I know, right? Let's see. We're gonna start off with Judge DiSanto, and we're gonna finish off with Judge Dad. Only two judges tonight. Got one case with Judge DiSanto, and then I think three or four with Judge McNally. He had a crazy docket today. We'll get there. We'll get there. First, we have a extremely entitled kid in front of Judge DiSanto, and man, he is. You know what? Not gonna spoil it. Not gonna spoil it. We're gonna get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right, so we are on the record in the matter of Carrie Wozniak, 232380. And counsel? Oh, you're muted, Mr. Westmoreland.
My apologies.
Okay.
Good morning, Judge. Attorney Corey Westmoreland appearing on behalf of Mr. Wozniak. Mr. Wozniak, would you please state your full name for the record?
Carrie Lee Wozniak.
All right, and so today's the date scheduled for a motion hearing. Mr. Wozniak is on probation. The court sentenced Mr. Wozniak to 6 months probation on May 13th, 2024. And probation has not terminated because Mr.
Otto. I don't know why. I feel like I had to say Otto back after the ... after my name.
Wozniak has not completed a couple items. And so Mr. Wozniak filed a motion to amend his conditions. And counsel, this was filed by Mr. Wozniak, and you did not file the motion, correct?
That's correct, Your Honor. And I don't even have a list of anything from probation regarding what he still has to complete. But after...
Oh man, I was cleaning up from dinner, kind of putting dishes away in the kitchen.
Reading the motion that Mr. Wozniak did...
and I had the volume going on my laptop. I was letting my headphones charge. I heard the scream and I was like, oh man, I gotta go put my headphones in. Came running over, put my headphones in, went back into the kitchen, instantly put my hands in, got my hands wet. I was washing dishes. And I had my headphones on max because I'm deaf. It's what I do. And man, it was terrible. I had to take them out of my ears. Oh man, it was bad. It was a good case, or a good. It wasn't a case. It was a body cam. It was good. It was just really loud.
Did file. I would like to point out that had not been mentioned in there that Mr. Wozniak has not accrued any new charges since he's been on probation. He has been diligent. He has made a good faith effort to pay all of his costs and fines, which he would be able to pay off his balance in full by the end of today. All the while remaining gainfully employed full-time at USG in River Rouge. At this point in time, I just ask for consideration to release Mr. Wozniak from probation.
Okay. So let me just state this, that Mr. Wozniak was sentenced on, he had his original charge was disorderly conduct. It was amended to disturbing the peace. The court sentenced Mr. Wozniak to 6 months probation, eligible for early discharge. And here is what the court ordered. As far as the GED and anger management. So really what the court ordered was there was random testing and not choosing any alcohol or drugs unless prescribed. An anger management, 8-week anger management class. The court ordered virtual would be permissible. And the court also ordered your client to work towards his GED as he left high school in the 11th grade. And so the court also noted that defendant was to look into what the time commitment was, and then the court would determine whether or not that condition would be waived. So I don't have any communication from Mr. Wozniak prior to December 3rd when he sent the letter in asking if there's any way that those two conditions could be taken off. So what I have some concerns with is that this court already made some concessions for Mr. Wozniak and was allowing him to participate in the anger management classes virtually due to the time constraints with his job. Further, the court ordered Mr. Wozniak to do some research back in May and even June to determine what the time commitment would be, and then the court would determine if it was going to waive it or not. It appears as though Mr. Wozniak didn't do any of that. He did nothing. So
Judge, I did speak to Mr. Wozniak regarding obtaining his GED. At this point in his life, he's 25 years old, and he has a very, very good job that he's earning, some would argue more money now than he would be if he even did obtain his GED. So that's, for him to take the time, and he wouldn't be able to work as much to obtain a GED. It just, there wouldn't be a benefit for him at this point in time.
Yeah, here's the thing. It was a court order. He's probably right. His attorney's probably right. You're gonna the defendant, Mr. Wozniak. Oh, I don't like saying that. Makes me think he's the Mr. Wozniak. Anyways, when he gets into his job, he's probably right. As of right now, it's probably a waste of time for him to get his GED. Here's the thing. It was a court order. Why is the attorney trying to just brush this off? And yeah, just wait.
Okay, well, counsel, I will say that I respectfully disagree that there's no benefit in having a GED. In the event Mr. Wozniak gets injured and then he can't return back to that work, having a GED would then put him in a better position potentially to,
Mr. Wozniak, does your current position require you to?
Counsel, please, I'm not done. So I disagree that it wouldn't do him any good. Second, Mr. Wozniak does not have any indication that he had looked into the time commitment required before December. Mr. Wozniak,
Yes.
what information and when did you gather the information regarding the time it would take for you to complete your GED?
I didn't because of, one, my job. I don't have scheduled days off. I work a swing shift. I got a son. I just, and like you said, I honestly don't have time to do it. And like I said, in my life, I'm 25. Last year I made, I think my W-2 said 73,000. Me personally, I don't see a benefit because in my job, I work a line right now. If I want to, down the road, I can, because they got electricians and mechanics here. I can go into mechanical. I can go into electrician. However I want to do.
Sir, you don't need a GED for that or a high school diploma?
Through my job, no.
Okay, so tell me about your anger management classes. When did you look into that, to scheduling that?
The first time I did it, when I first started it, all the classes seemed to be, because I work.
All right, real quick. So what he says he works the line. He's in construction. Now, my ex-brother-in-law installed pipelines, and he made a ton of money. It was grueling work though, and he graduated high school though, and he didn't go to college. He started this job after high school, and he made a lot of money. Here's the thing: about 5, 6, maybe a few more years after that, he was completely burnt out. He was working 60, 70 hours a week. He would have to drive sometimes 2 or 3 hours to a job, and like so he found another job. Like, here's the thing: yeah, it's really good paying work. It's not easy and it's grueling. There's a reason why you don't need a high school education to do it. So he's making a lot of money now, and good for him. But yeah, out really quickly. It's a young man's game to do that.
6:45 to 3 in the afternoon for 2 weeks, and then the other 2 weeks out the month I work 3 in the afternoon to 11 at night. All those times they never like. I wasted $100 one time because I scheduled it and I was like 23 minutes late to the class because I got off at 3, and it started at 3. And the times just never added up, or I could never be on time for the class.
Sir, and that was virtual?
You said what?
That was virtual class?
Yeah, but if I'm driving, I can't be on the phone driving home on the class or.
So, sir, at what point did you contact into probation to see if they had any other options or if they could communicate with the anger management program for you? At what point did you do that?
I mean, I told Natalie my situation, and then she told me she couldn't do anything to waive it, or I would have to write that letter or ask you, get a court date.
Sir, my question was when?
Couple months back, I told her this.
Right, in December.
I told her that before December, and she just kept telling me to schedule the classes, but I don't want to schedule it, and if I don't make it, I'm just wasting my $100. Like I wasted $100 once. If I can't make it, I'm wasting another $100. That's why I never scheduled another class. If I can't make it, I just don't want to continue to waste my money.
So, sir, when you register for the virtual classes, did you communicate with anybody to see if there was another time that you could jump into the other class based upon your schedule?
From what I was told, the classes started at 3.
Sir, that was not my question. Did you inquire with the company that you registered with whether or not they have other class times, and if you could jump into those other class times on your swing shift on the opposite shifts?
I want to say I did, but like I said, like if I'd be at work during those times of the class. That's what.
Sir, you're not hearing what I'm saying, what I'm asking you. So on the weeks that you work during the day, you would presumably go in the evening. And then in the weeks that you work the evening, you could presumably go during the day. So that is what I'm asking. Did you ask the company that you were looking into whether or not they had different times that the program was offered, and if you could adjust which time that you attended based upon your swing shift schedule? Did you do that?
Yes, but it's one class. Like it's like how you told me to do the chemical program class or whatever that was. It's like a class of people, and it's how that was.
You weren't ordered to do the chemical awareness program. I didn't order that.
Well, are you sure? I don't know if that's what it was called. It's where I had to do the 3 Mondays in December from 7 to 9.
For this case?
Yes. And I got emails.
I didn't order it. I didn't order it and I didn't charge for it, sir. So I don't know.
Well, I'm almost positive you did, because when I was first on probation, I was dropping dirty for marijuana, and that's why you put me on it. And that costed me another $100 because I missed that number.
Hold on, sir. So yes, so there was a probation violation in October of 24, where the court extended your probation 3 months and ordered you to do the chemical awareness program. That is correct. So it wasn't a condition of your probation. It was as a result of your violation.
Yeah.
So, sir, here's what I'm trying to say. You had 2 conditions that you needed to complete for probation, and you haven't done either one of them. And now you're asking the court at the end of your probation term to waive both of those conditions. So then what is it that you've learned to modify your behavior so that you're not doing this again? Do you see what I'm saying?
I mean, I tried telling you my very first court date, but I don't know if you heard me or not. I tried telling you my whole situation with my job, and then like, it's a good job. I'm not trying to lose my job. I got a son to take care of.
Sir, I did hear you, which is why I indicated that I wanted you to look into the time commitment to determine what it was, and then the court
Heather.
would determine whether or not it would waive it for your GED. I also heard you because I agreed for you to be able to do virtual anger management classes in 8 weeks of those, not 12 weeks and not in person. So yes, sir, I did in fact hear you. I made those concessions and you have done 0 of the conditions.
I mean,
Now you want this court to waive those conditions.
I don't know what to say. It's just the only reason I can't do it is because of my job. I do not want to lose my job. Like, my thing, you put me on anger management because you've seen something that happened. I want to say it was 2017 or 18. I'm young.
Yeah, he's not lazy. It's kind of hard to be lazy with the job he has. But he's, sticking his nose up at the court for sure. He can absolutely get a GED and take that anger management class. He might lose a day of work though, and that's what he's saying. He's not going to do. No, here's the problem though. He's saying he's not going to do it. He had no intention on doing anything, and he's just telling Judge DiSanto, I'm not doing it. Like, yeah, come on, Judge.
Young now, but I was a kid back then. Like, I since that incident that you put me on anger management for, that I don't know what it was, something in Flat Rock. This is the first time I've been in trouble. Like,
Sir, you had an 18, you had a disorderly person jostling. 19, You had a disorderly person, and then you had this matter, which was a disorderly person. So yeah, this court determined, after review of everything, that you have some issues with, being in frustrating situations and not getting in trouble. So yes, so that is what this court ordered. So, sir, here's what I need for you to do. I need for you to send in to Ms. Shaw the names of the programs that you've looked into for anger management and what accommodations those programs can make for your job, if any. But I need to hear from those programs.
Now, what if there's no accommodation they can make? Like, then what? Like, I feel like you're not understanding that. Like, I do not want to lose I make $32 an hour. I don't want to lose my job over. I mean,
Sir,
I'm not even.
Stop. Please do not assume what I understand or not understand. I am 100% understanding you, which is why I gave you those accommodations at the beginning of your probation in May. That is why I did that. I don't regularly permit individuals to do virtual anger management. Okay, I think you're the first one that I permitted that for. So to say that I don't understand is not accurate one bit. What you don't seem to understand, sir, it appears, based upon the lack of communication since June until probably November or December, and your continued comments to this court, that it does not appear as though there's been much effort to locate an anger management program virtually that will fluctuate with your schedule. Or maybe it doesn't, but I don't have any communication, anything in writing from the multiple programs that you've looked into that would state that. So that is what I need to see before I determine whether or not this court's going to grant your motion or not. Maybe there's a program that, they run simultaneously. So on March 1st, there's a day program and an evening program. And 2 weeks you can do the day program, the next 2 weeks you can do the evening program. And so they run simultaneously with the information that they're discussing in each of those. And so then it would make sense. Maybe it doesn't. I don't know, but you haven't given this court anything to support whether or not that would work with your schedule. Okay? So once I have that, then I will make a determination on your motion. So what I'll do is I will adjourn this Can you get that information within 2 weeks, sir?
I can try. I don't even remember the place that I called because it's been so long. Because like I said, I'd have to call Natalie and get some places because I honestly don't even remember the place because I don't want to just waste. I didn't want to continue to waste my money.
Okay, but you didn't contact him to get any other places?
I got.
Or did you?
She gave me
do
one
some-
place and I
Sir?
scheduled the class.
Did you
I
do
didn't-
some research on your own to find out some places to make sure that those, and then communicate with Natalie to see if that would work?
Well, I don't even know what you want me to look up. Just anger management. Like
Yes,
I
sir.
honestly communicated good myself. You guys just
Sir?
I like.
Sir, do you use Google?
Yeah, I know how to use Google.
Okay, so if you're looking for something, what do? You put it in Google, right? So you do the same thing for the virtual anger management classes. So we'll adjourn this for 2 weeks. We'll adjourn this to February 25th. Mr. Westmoreland is not here that day, but Mr. Shunke will be here.
I'll make sure Mr. Shank first on the matter.
And sir, on February 25th, are you on your day shift or your afternoon shift?
I'd have to look. Give me a second. Let me go to my calendar. I'm on afternoons.
Okay, so that shouldn't be, all right, so then we will do 9:30 a.m. All right, thank you. Have a good
So
day.
I got one more question.
Okay,
So was that this one you just adjourned? Was that for just anger management? Or was that for the anger man? Like, what was the deal on the GED part?
well, you're supposed to look in to see what the time requirements would be, so that I can make a determination whether or not I'm going to waive that.
So you still want me to get a GED even though I'm
Sir.
making
Sir, what I'm asking is for you to look
25
into-
years old?
I'm sorry?
I just don't get it. I'm 25. I got a kid. I make 70,000. I mean, it might not be much to you, but 73,000 for a 25-year-old. I mean, that's decent money.
Mr. Wozniak, again, please stop making assumptions.
I'm not making assumptions.
I do think $73,000 is a lot of money. What I'm asking you to do, sir, is what I asked you to do at the beginning of your probation. Find out the time commitment that it would take for you to get your GED.
Well, okay, can I ask you? Oh, go ahead.
And then I will make my determination as to whether or not I will waive that condition.
All right, yo, guy, this is all you have to do. Figure out how long a GED program is. That's all you have to figure that out. That's all she's asking. Go back with that and say it's going to take me 3 months to get my GED. You're trying to get off probation. She might release you on off probation right then and say, I really want you to take this, but I'm going to waive it. Just do what she's asking. All she's asking is you to find out how long it's going to take. That's all she asked. She didn't say, hey, you need to get your GED. She wants you to get it, but she didn't tell you have to get it. She just wants you to do a little research on it. At least that's what she's saying now.
Okay. Well, what would be the benefit of me getting it to you?
The benefit.
Of me getting a GED? Like, what would it do for me as of right now?
Sir, let's think for a minute. Let's say that you're injured, right? Let's say that you get injured and you cannot return to work. Or let's say you get terminated and you cannot return to work. Then having your GED would potentially expand the locations that you would be able to get employment, sir. So right now you have a very good job. I don't disagree with you. You have a good paying job, you're able to provide, but in the event something were to happen, so that's where I'm looking, sir. You have to kind of look in the future to see, you can't guarantee what's going to happen or not going to happen. So that's what I'm saying. That's what the benefit would be to you.
You're right, but if I do get injured on my job, I get medically paid if I get injured.
Okay.
I got a 401k if I get,
Sir,
like,
where did you get terminated?
I'm not going to get terminated. Like, why would I get terminated? That would be my fault. I would have to do something really dumb to get terminated, and I doubt I'm going to do that. I'm not trying to like argue. I just don't.
Oh,
I
but
just
you
really
are.
don't see a benefit in me getting it.
But you are. And I stated in May what the rehabilitative condition was for that. So I've made my ruling right now. You need to get those, need to get that information on the anger management programs and on your GED, and then I'll make my determination in 2 weeks. Or
Disturbing the peace. Okay. So you said what? For the 25th, you said?
Yes.
All right, bro. That's so crazy.
All right, bro. Now I gotta grow. All right, great. All right, we'll see you on the 25th at 9:30.
Well,
Have a good day.
Thank you, Judge.
Okay, thank you. Okay.
Okay. Yeah, that guy was a slightly bit entitled. Yeah, I'm so much better than the GED. I'm so much better than it. Give your GED, kid. What's it gonna? It's not gonna hurt you. A couple hours of your time. I mean, he doesn't seem like a dumb kid. He doesn't seem dumb. At least he doesn't seem. Uh, I don't know. He does seem kind of dumb, but he doesn't. What am I trying to say? I don't know what I'm trying to say. I feel like he could get his GED rather easily. Is what I'm trying to say. That's my point. I don't think it's going to take him months to get his GED. I think he can just get it in a couple weeks. That's what I'm trying to say. He's entitled. He's got an attitude issue. Lots of stuff about him. I just don't think it'd be difficult for him to get his GED. He seems very well spoken, and yeah. Okay, let's move on. Let's move on before I. Yeah, that's a better way to put it, Dorina. Thank you. Thank you. All right, next we're going to Judge Dad, also known as Judge McNally. We're gonna hang out with him for the rest of the night. Got about 4 cases from him. Also, I do want to say it is 8:27. We have 4 nights in a row at 8:30. My internet cut out. Hopefully that doesn't happen tonight. But just warning you before it goes in. If for whatever reason I drop, I will come right back. I promise. All right, Gertrude. Thank you. Thank you. Welcome to the family. I appreciate that, Gertrude. Okay, let's go. Judge Dad.
But then I got the email that we're starting here at 9. So I'm letting Woodhaven scream at me a little bit. You got your phone. I got my private.
Woodhaven.
It's McNally.
Yep, that happened. That happened. I don't know. Did I jinx myself? I don't know if I don't know if you could say I just if I if it's just been happening at 8:30. Just knew that I was gonna happen, and the last couple nights it hasn't been just one and done either. It's happened a couple times back to back. So just warning you guys. All right, let's go. This attorney is kind of he's not talking shit about McNally. Why can't I get okay? He's not talking bad about Judge McNally, but the reason I put this clip in there is he All right. All right. I got kicked all the way out of StreamYard that time. Usually it just shuts me down for a minute. I actually got the boot. All right. Sorry guys. I'm hoping that's it. All right. All right. Can you guys hear me? Let me load the video, so we might be okay. Oh, let's just. I don't have any words. I'm just gonna play. Sorry guys. I appreciate you guys hanging out. This is beyond annoying. All right. We'll just play.
Yeah.
All right. The video kind of loaded. Can you guys hear me? Oh, it is. It is. Usually this only lasts a few minutes. It's been way too long. All right. I'm just gonna play it. Hopefully it works.
Starting here at 9. So say something. This man ages so well. He was a transfer. They used to do this thing where they would bring district courts to recorder's court and they switch back and forth. 20 years ago, I had a homicide trial with McNally in recorder's court.
Really?
He doesn't look any different. He doesn't look any different. I'm like, well, good for you.
All right. The reason I had that in there, which I was trying to explain before my internet debacle, that attorney is now in front of McNally. He just said that he's going to let Judge McNally yell at him. He doesn't really care. He just said that to another judge. He said it to Judge Slavens. On a day where Judge McNally is just getting fed up with attorneys not showing up for court appearances while they're on Zoom. Okay. That's why that was in there. Let's go.
Yeah, I know. I'm getting ready to cancel Zoom on all of these lawyers. Let everybody come in. This is just.
Mr. Cooper, did you want a breakout room first?
You want a breakout room first, Mr. Cooper? Mr. Cooper?
A breakout room with my client? Yes.
Do you need one? Okay. Gregory Lynn Sorrell, 25W702221.
No, Sparkle. First off, thank you so much, Sparkle. I appreciate it. And my appointment's on Thursday, so that's so not tomorrow, but Thursday. Nanya, thank you. Wow, Nanya, that was very generous of you. Thank you, Nanya. Oh yeah, thank you. I appreciate it. Yes, thank you for that as well, Nanya. Very generous of you.
Michael A. Carmen, P73824 on behalf of the defendant.
Sir, your name?
Gregory L. Sorrell with frostbite feet. Gotta get to the hospital here.
Do you want a 1-week adjournment? Is that what you want?
I want a court date set up. I'm not guilty on any of those charges.
Your Honor, we do need adjournment of the pretrial so that I can get discovery, though. I do not have it.
Appearance?
Good morning, Your Honor. Mohammed on behalf of the people.
We're gonna adjourn this 1 week to February the 11th. You'll get him discovery?
Yes.
Okay, and we'll make it at what time, Lisa?
9:30.
At 9:30, okay? Bond is continued.
Could have did that a long time ago. Shit, set up all these other cases for what? My feet frostbite. You should be frostbite. You just said it. Oh, shit.
Good luck, Mr. Sorrell.
Yes. You have a blessed day. Yeah.
You too, Deputy. Thank you.
I am the blessed.
That was a quick hearing. We covered the first part last night on Members Monday, so that was part 2. For all the members who saw it last night, that guy's a character, right? Okay. Now back to Mr. Cooper. Mr. Cooper, the attorney, is the guy who was in Judge Slavin's courtroom at the start of this clip.
Javari McGill Holmes, 214-717-623.
Good morning, Your Honor. Mohammed on behalf of the people.
And good morning, Judge Renee Cooper, on behalf of Mr. Holmes, who I have been speaking with all morning, and he's on.
We need him on. Hang on. He was in the jail, wasn't he?
Yeah, he's supposed to be coming from Zoom.
I'm trying to move
I
him.
was informed that Detective Driscoll's been waiting to be entered into the Zoom hearing.
Yeah,
today.
Detective Driscoll, I saw appear here momentarily.
They were brought in and put into a breakout room with Mr. Cooper. I'm just trying to move him back out. It's not moving.
Technology.
I'm telling you, I'm getting so sick of Zoom.
Yeah, it's getting tiring.
It is.
Yeah, Mr. Cooper, you were just in another courtroom saying that you're going to make Judge McNally mad and you don't care. Now he's sitting on here like, oh yeah, I agree with you, Judge. Come on, man. You're one of the attorneys he's complaining about.
I just
Hopefully
closed all the
go back
rooms
to
to try to get him out, Judge.
No, I understand. Take your time, Lisa.
I do think we might have like 20 seconds of dead time, but maybe not.
Here you are. Your name, sir? I need you guys to unmute there, Detective, and then both state your names.
Can you hear us, Judge?
Yes.
Javari Holmes.
All right, Detective?
Detective Sergeant Mark Driscoll, Trent Police.
So we're supposed to be doing the exam today, right?
Correct, Judge. So on Friday, I had an opportunity to speak with the detective, the defense attorney, the victim, and I even went to my supervisors because the defendant in this case is a habitual fourth, but the officers, some of them include, they live in Ohio. So we got a plea done on this case.
A plea?
Yes, to a misdemeanor.
Okay.
No.
And I really, please let me finish speaking before you interrupt.
Hang on, just let him finish, Mr. Cooper. Go ahead.
And so I extended it to defense, and my understanding is that the defense attorney was trying to get a hold of his client and wasn't able to. And so I was under the impression that this case was going to be pled out due to, extremely generous offer in this case, based on the circumstances.
So you called your witnesses off?
Yeah, so there was no witness, so I didn't subpoena them because I anticipated that they.
So you made an assumption, Mr. Muhammad.
Correct.
That you shouldn't have made.
Correct, but you're right. And if anyone's fault, it's mine, and I'll take the full responsibility for my witnesses not being here. But I was also under the impression that it's going to likely be pled out just based off of my discussions. And so then I reached out to defense counsel yesterday, and he was attempting to get in touch with his client, and he was under the impression that he was in the Wayne County Jail. But then I learned from the detective in this case that he was actually in, I think it was Macomb or Monroe, one of those, or Washtenaw, my apologies. And I relayed that to defense counsel, and then he attempted to make contact. He wasn't able to speak to him until today. And it's my understanding that the defendant is not accepting the plea offer. So respectfully, I'm requesting a 1-week adjournment. If it's not granted and the court decides to dismiss this case, it will be reissued and this process will start right back over. And, you know, this plea offer was extremely generous.
But they don't have to take a plea offer whether you think it's generous or not.
I understand that, but
you made a mistake. You're a young lawyer. You shouldn't do that. Don't do that again. Mr. Cooper, what do you have to say?
I'd like the matter dismissed, Judge. I don't want to go through the whole sequence of events the way I see them. I just would like the matter dismissed. There's no witnesses there.
Gotta be really careful. I'm adjourning 1 week.
I can't be there in a week, Judge. I can't do that week. Wait.
Put your hand down.
Put your hand down. I start a trial on Tuesday, the 11th. Judge, right. I would ask that you ask. I would ask that you ask the prosecutor if the witnesses were even subpoenaed.
Judge, really quick. Judge, may I interrupt really quick? Sorry. Mr. Holmes, I know I'm not as a counsel, but he just talked to me, asked if he could convene with his attorney. He's reconsidering taking the offer. Obviously, he needs to talk to his attorney prior to that. That's why he had his hand raised.
I see. Mr. Cooper, do you want to talk to him?
Sure, Judge, if he wishes to speak, absolutely.
I'm not going to change my mind on that. If you can't do it next week, I'll set it for the 18th. I get it. He's a young prosecutor. He made a mistake. Don't proceed on assumptions. That's the bottom line. I mean, he didn't tell you you should have had them subpoenaed anyway long before Friday, but that's neither here nor there. I'll let you talk to your client again. And you come back in here and tell me how you wish to proceed. It's a 2-year, right? All we have is a UDAA, or wait, what do we have here?
So it's a 5-year.
Right, one 5-year felony UDAA, right?
Correct, and it would be reduced to unlawful use of a vehicle, which is a high court misdemeanor.
All right, well, he's left, so give him a minute, and let's see what they come up with. I don't know what to tell you. Demetrius Deontay Johnson, 24W7271792, and I'm also.
Oh, I actually kept this case in here. I forgot. There's still another part to that, and it gets better. It gets better. But yeah, the prosecutor, man, didn't subpoena your witnesses because you assumed they would take the deal. It is a sweetheart deal. And yeah, you saw the defendant. The second judge is like, "Oh, I'm not dismissing it. I'm putting it out a week." It's like, no, I want it. I want it then. If you're not going to dismiss it, I want it. Yeah, that offer might not be there. So good on the defendant for not letting his attorney ruin that for him.
Calling Dejan Latrell Lindsay, 24B727-207 and 24W7271791. Ms. Watt, your name?
Good morning, Your Honor. Coral Watt appearing on behalf of Demetrius Johnson, P41508.
Mr. Collins.
Good morning, Your Honor. Harold Collins, P56805, on behalf of Mr. Dejan Lindsay, who is not present in the courtroom nor on Zoom, Judge.
All right. I need you to start your video, Mr. Collins.
Okay, Judge. I'm mobile. I'm pulling over to the side.
Yeah. Zoom deals are about to disappear on PCCs here. I don't care who wants to tell me what. It's going to happen soon. February the 18th will continue to be the exam. We're going to set that out at 10 o'clock in the morning. February 18th at 10. Have him read it out, Mr. Lindsay. And then on to. What's that?
That's the same date that he has another hearing in Macomb.
Well, then let's do it next week. I'm
Judge,
issuing a warrant on, guys, you're killing me on this one.
Yeah.
Well, you can't do it the 11th either?
Yep.
Judge, if I may.
I'm issuing a warrant on your client, Ms. Watts, so this isn't gonna concern you. I'm just telling you, he didn't show, he was here. I'm issuing a warrant on Mr. Johnson. I'm setting 75,000, 10%, and we are gonna issue a show cause against the surety company as to why the bond ought not be forfeited for his failure to appear. So that's what I'm doing on yours. Now, so you're all set, Ms. Watts. Sorry about that.
Thank you, Your Honor. You have a good day.
You too. Mr. Collins.
Yes, Judge.
I can't move it. I'm not going to be here the 25th. I can't move it to the, he can't do the 18th. I'm not moving it to March. This case was arraigned December 27th.
Judge, I understand, you know, it's been some complications, not of our doing. I have an exam at 10 o'clock on the 11th in 36th District Court. And so I don't know, Judge.
What time? Hang on. Does Judge Heston have anything going next Tuesday afternoon, Lisa?
Let me check. She does not. Can I just say something though?
Yeah, it's going to be something I don't like, but
Well,
yeah, you can say it.
It's just that if he's in Macomb, we have to send someone to get him. So if we wait till after the 18th, he would be transported from Wayne County.
Yeah, Judge, that'll be better. Let's get him back in our hands and set a date. I know you're not there the 25th, but you
guys, listen, I mean.
Judge, also.
Hang on. Let me talk a second. This is an RNC motor vehicle case. 95, hang on, let me finish. 95 to 98% of these waive. They don't want to waive, it's okay. But I got to do it at some point. You're killing me with my time guidelines here. I mean, I'm not going anywhere. This is my last term, but I still am a rule follower to the extent that I'm supposed to be. And I don't want to adjourn it to March, Mr. Collins. So you're saying you can't do it the 18th because your client's got one there. You can't do it next week. Why can't we do it in the afternoon at 1 p.m.? Are you here on this one, Detective?
Yes, Your Honor.
Any reason Woodhaven can't go get him and bring him here go to Macomb and get this guy and bring him here next week?
Yeah, Your Honor, we can make that happen.
1 o'clock, February the 11th. You can do your one in Detroit, and 1 o'clock we'll set it. We'll have your client here and we'll go from there. That's the best I'm gonna do. Sorry, guys.
Okay,
Sometimes
Judge.
It's very not, it's tough to be popular sometimes as a judge. Thank you, Detective. He's here. We'll sign the writ. Thank you very much, everybody. See you next week at 1 o'clock. Angela Bellinger. Angela Marie Bellinger, 214-725-324.
Michael Lee Carlin, P7324 on behalf of the defendant, Your Honor.
Your name, ma'am?
Angela Marie Bellinger.
All right, so he brought he subpoenaed them. All right, so here's what we're gonna do. We're gonna set this for a bench, right?
Yes, Your Honor.
Is that what you wanna do, ma'am?
Yes.
You have the constitutional right to a jury trial. In a jury trial, 6 people would be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. By waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand that?
Yes.
You still wish to give up your right to a jury?
Yes.
Anybody force you to do that?
No.
I'll accept the waiver. We'll set it for bench. When are we doing this one, Lisa?
March 4th at 1 p.m.
March 4th at 1 p.m. Good with you, counsel?
Works for me, Your Honor.
All right. I'll accept the waiver.
Okay,
I'm
Mohammed.
signing the waiver of trial by jury form, and we will set this for next week. I'm sorry, for March the 10th. March the 4th, rather. March the 4th at 1. All right, you ready, Mr. Cooper?
He wishes to take the misdemeanor. We need Mr. Mohammed. I think he is
Okay.
writing up the.
I don't know. Good. Mr. Mohammed must have taken the file, so we'll wait for him to come back in and I'll take care of that. Jacqueline Lee Luna, 24B7.
All right. We fast forward about 20 minutes on this, and our good buddy, Mr. Cooper, he had another case. So he has whatever device, it's probably his computer, judging from the angle. He's in another courtroom right now. Judge McNally's trying to get his attention, and you'll see. You'll see. Before I do go any further, though, Vic, thank you so much for the Venmo. Very generous of you. I appreciate it. You're awesome, Vic. Okay. Let's go. I actually.
People against. Jabari McGill Holmes, 24T717623FY. Mr. Holmes, your name?
Javari Holmes.
Good morning, Mr. Cooper.
I think he's in front of another court now, Judge.
Yeah, this is why we got to do away with Zoom.
Oh, man.
Yep.
Do I have another file in front of me?
I kept this in here on purpose because we're going to get to hear a little bit of the hearing that Mr. Cooper's in here in a second, and it is hilarious. It also kind of shows you what kind of attorney Mr. Cooper is. I don't think I like him. I don't think I do. Oh, it's absolutely amusing. Especially when Mr. Cooper unmutes
Gentlemen,
that
I gotta wait. He's in front of another judge.
Absolutely.
Hey, Beverly.
Oh, okay, he's already on Taylor, just let me know. Oh, that's right, okay, yeah, that's all. Mr. Carnes in this, Judge Hass's courtroom, he said that's a no-show, Taylor.
People against Rachel Lynn Taylor, 24T726823. Defendant's represented by Tony Carmen. He's in front of another judge, but he has advised this defendant failed to appear for the show cause. She initially failed to appear for the arraignment. In pretrial back on January 7, we show caused the defendant $7,500, 10% warrant issued, bond to be forfeited. Do I have a? Yes. That's it.
So you're saying that my suspicion that I don't like this guy is probably true. I could have worded that better, but you know what I mean. All right, he's about to unmute now, and it's funny.
About anything. It is in person only. Zoom is a courtesy. We needed it in COVID. We no longer have a COVID problem. In person only. That understood.
No, that's not understood.
Judge, can I just withdraw? I just have to go. I'm not doing this client.
Mr.
I'm trying to tell you, I have no support. I'm the only one, and I don't have a way up there.
Then start walking. I'll see you tomorrow morning.
And Judge,
Can I withdraw?
Question at KPS.
Please don't have, I can't do this, man. I have to withdraw from this case. Stop. I need to withdraw. I got messages from everywhere, from him and I'm not doing it. There's some ethical issues or something. I just need to withdraw.
I'll see you.
For me?
tomorrow morning, Mr. Gray, I'm not having it on Zoom. You pled guilty to carrying a concealed weapon, 5-year penalty.
Now, if you don't show up, I'm going to review this. Look at this shit.
Officer, I have read the sentence report. It speaks about various PPOs that were denied. It also speaks about a PPO that was in the hands of another police department and validated the accuracy of the personal protection order. I'm not arguing about this anymore. There are so many PPOs sought.
Judge, I start a trial tomorrow morning.
From here, like where we're at now.
So, how about
That's not Judge Shackelford. It's Judge Ramsey Heath. He's going to say it here in a second, but no, it's not Shackelford.
that for it?
I appreciate you letting me withdraw, Judge. I appreciate it very much. Yeah, she did.
Needed in another trial. He is absolutely asking to withdraw and not giving me choice. Why can't we do this sentencing tomorrow morning, Mr.
I start a trial tomorrow morning, Judge, before Judge Cox. No, there's too much else going on, and
Please, if you understand.
shut up, man.
Tell me when your trial's over.
No, Judge, I'm not representing him. I'm just not going to. I can't represent him. I've gotten too many mixed messages from, no, there's games going on, and I don't want to say negative things about him, but I'm not doing it. I'm just not doing it.
Can we do it now?
Judge, gotta go.
Are you withdrawing your objection to the PPO?
It was never me. It was somebody that.
I'll be back when I can't.
Yeah, he just walked out of that courtroom mid-hearing. The judge didn't excuse him. The judge never said, I'm allowing you to withdraw. He actually said, thank you for letting me withdraw from this case. She never said that. We heard it. Man, I wish Judge Ramsey Heath was still on YouTube because I would absolutely love to see what actually happened in that courtroom. Because, yeah, the attorney does not look good from what we just saw.
I'm very sorry, Judge McNally.
That's all right. I thought you were just doing, I thought you were doing that for our entertainment there. I didn't know what judge you were in front of.
No, it's another Zoom problem. Another Zoom problem.
Don't worry about it. Javari Nagil Holmes, 214-717-623. Mr. Holmes, your name?
Javari Holmes.
Renee Cooper on behalf of Mr. Holmes.
Detective, your name?
I would think so. I don't know. I've always seen a few cases in front of Judge Ramsey Heath. She mainly did landlord tenant when I watched her though, so I haven't really seen her in front of anything criminal. So I still think she would reprimand him in some way for that.
Detective Sergeant Mark Driscoll, Trent Police.
Before I start, has he been printed?
He has, Your Honor.
Thank you very much. So I have a stipulated plea agreement here that tells me that the defendant's going to plead guilty to attempted unlawful use of a motor vehicle pursuant to MCL 750.414, which is a 1-year misdemeanor, and the UDAA, the 5-year, will be dismissed. Is that right, Mr. Cooper?
It is right, Judge.
Is that what you want to do, Mr. Holmes?
Yes.
If you plead to that charge on attempted unlawful use of a motor vehicle, that is a 1-year misdemeanor. I'll then dismiss the felony. Do you understand that?
Yes.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial. You have the right to remain silent. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in those witnesses. You have the right to testify, but if you choose to remain silent, that silence would not be held against you. Do you understand that?
Yes.
If you plead guilty, we're not going to have a trial and you're giving up all those rights. Do you understand that?
Yes.
To the charge, attempted unlawful use of a motor vehicle, how do you plead?
Guilty.
Were
Responsible.
you, in fact, at or near 1659 Boxford in the city of Trenton on June the 27th of 22?
Yes.
Did you take away and use a 2017 Ford Expedition that belonged to somebody else?
Yes.
You did not have permission to use that, and you did not own that motor vehicle. Is that true?
Yes, correct.
Right now, are you on probation or parole?
No.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty other than a dismissal of this felony charge?
No.
I'll accept your plea. I find it to be an accurate plea made voluntarily and understandingly. I'm going to dismiss the UDAA. I'm going to refer you for a pre-sentence report. We're going to have probation get on. They can do the report this way. Is he still got a case? You still got a case going on in Washington, all right?
He does.
So let's pick a date for sentencing. So we're going to get probation on there to talk to him now. And I'll let you pick a sentence date any Tuesday, Mr. Cooper, except the 25th. I'm not going to be here. I'm at the drug court conference that day.
Okay, is this a Zoom or an in-person?
I mean, you're appointed. I'll do it by Zoom. But I am ready to get rid of Zoom. I'm telling you, I'm getting tired of it.
It's bad. Okay, you say anything but the 25th?
Correct.
Oh, that's just.
The 18th. I can do we want to do it on a Tuesday, either the 11th, the 18th. What would be would that be the 4th of March? Yeah, the 4th, the 11th, I could care less. And then I will address bond on this gentleman. Don't make this worse than it is, Mr. Holmes. You make things worse than they are when you do not show up. Do you understand what I'm telling you, sir?
Yes, sir.
All right, go ahead, Mr. Cooper.
I'm looking at the 11th where I started trial before Judge Van Houten. I'm looking at Tuesday, the 18th, where I'm in front, trial in front of Judge Ramsey, where I just left. So how about the 18th? Because I seem to be getting my way there. Okay.
Are you sure you want to do the 18th? I can do it another day if you.
The 25th is wide open, and I can't do that.
I could do March the 4th.
Oh, okay. I mean, I have a trial before Judge Cobb on the 3rd, but I can get Judge Cobb to.
Well, then let's do. Is it more convenient on the 21st then? I mean the 18th.
The 18th is it's Judge Ramsey, and I can work something with her. She'll let me do it.
Let's do it at 9 o'clock on February the 18th.
Okay.
Mr. Holmes, I will entertain a motion to reduce the bond on this. He's been in custody, it appears on this case, for already 90 days or so. I mean, the bond, he never posted, I don't believe. It was set at 30,000, 10%. Judge Heston set it on October 22. So what would that make it? November, December, January. Yeah, I mean, about 3.5 months. So he's been in custody for close to 110 days or so. Do you want to make a motion?
Well,
call in the prosecutor again, Mr. Muhammad.
I don't know that I do. I don't think he can get out of the Washtenaw County Jail.
Okay, that's all right. I don't know when this court date is, what his bond is there. I didn't know if this had something to do with it. That's fine. I'll continue the bond. I'll continue the bond and we'll make it on the 18th. Okay? 18th. February the 18th at 9. Anything else, Mr. Cooper?
No, I appreciate it very much, Judge.
Have a good day. Thank you. Good luck, Mr. Holmes. Thanks a lot, Detective, for taking care of that for me. I appreciate it. We're going to have the probation officer interview Mr. Holmes now. Okay, thanks.
Yes, sir.
What else do I have out here?
Oh man, that case felt like it was never gonna end. It was entertaining for sure. It just was dragging on. So one more. One more Judge McNally case. This one's not very long. Let's see. It's less than 10 minutes. So whew, let's go.
Mr. Schiller, your name? Your name? Mr. Schiller, I need your name.
Harlan Schiller, Your Honor.
All right, Mr. Schulman, your name? You're muted, Mr. Schulman. Mr. Schulman, you are muted. There you go. Mr. Schulman.
Yes, good morning.
Your appearance?
Yes, Sanford Schulman, P 43230.
Why do we need to adjourn it for 2 weeks? I don't mind the exam being in 2 weeks.
Yeah, no, I don't necessarily need 2 weeks. We had to, Mr. Schiller provided the erroneous information, which meant I couldn't contact him for today, but we straightened that out. I was talking to the wrong prosecutor because this is a DV case. I straightened that out. I have the discovery. So we're good. He's out on bond. 1 week is fine.
Okay, Ms. Louie, your name?
Good morning, Your Honor. Nora Ali on behalf of the people.
So you want to just adjourn the PCC for 1 week to February 11th and the exam to the 18th, right? Mr.
Yes.
Schulman?
Yes, and just,
All right.
Judge, I'm sorry, just as caveat, the people indicate there's some video discovery that hasn't been forwarded. I assume they can do that in an expeditious manner. But other than that.
You're going to get that to him, right, Ms. Louie?
Absolutely. I just received it today, so I plan on sending it in just a second.
Okay, excellent. Perfect.
Thank you. Mr. Schiller, you have the right to a probable cause conference within 14 days of the date of the arraignment. You have the right to a preliminary exam within 21 days of the date of the arraignment. Your lawyer tells me he needs a little bit more time to prepare. He's asking me to adjourn this 1 week on the PCC to the 11th and the preliminary exam to the 18th. Do you wish to give up those rights?
No.
Okay.
You can't confer. Oh, hang on.
No.
I don't know whoever's there saying no, but they cannot be involved in this. You got a good lawyer here. He needs more time to prepare. And I'm going to ask whoever's in the background there to resist the temptation. Do not talk to Mr. Schiller. Okay? You understand what I said, ma'am?
Yes.
Good. All right. What do you want to do? Do you want to have your lawyer be unprepared and have to come here and do an exam next week? Or do you want to give him the opportunity to prepare so he can have a preliminary exam in a week and a probable cause conference in a week and a preliminary exam in 2 weeks? It's up to you.
Yes, Your Honor, that is fine.
Do you waive those rights?
Yes.
You're looking at your mother, whoever that is again, and she's not a lawyer. Did she go to law school?
No, I'm just looking.
Well, then well, that's like me giving advice about how to fix somebody's arm. Give me a break. Do you want to waive that right? Or do you want to insist that he go forward without being prepared? It's up to you.
Your Honor, he needs to be prepared. So I waive the right.
Do you waive those rights?
Yes, I do, Your Honor.
Anybody force you to do that?
No.
February 11th at what time, Lisa? And February 18th at what time?
9:15 on the 11th and 10:30 on the 18th.
10:30 on the 18th. That exam has to be obviously that's going to be in person. You can appear by Zoom on the 11th, Mr. Schulman, at 9:15. Okay.
Very good. Thank you so much for that.
I'll see everybody here in a week. Thank you for. Oh, wait a minute,
Your Honor.
Wait. I got one. You're here on Schiller, right?
He's like, we almost got out of here. Yep, he's got a violation. Good job. Hopefully, Mom, the attorney, helps him out here.
Yes, Your Honor.
Is this yours? Oh,
yes, Your Honor.
I also got a complaint of violation of conditional release that we have to address, Mr. Schulman. Detective Attard, your name?
Detective Ronald Attard, Brownstown Police.
It says on February 3rd, victim Carrie Gell called Detective Attard, OIC of the original case, to inform Detective Attard of the bond violation committed by defendant Schiller. Following conditions: no contact with victim, jail. I don't know if I'm pronouncing that correctly. Defendant Schiller contacted Carrie Gill via telephone with the above date and time. He writes the phone number down. Defendant Schiller demanded to know where his vehicle was. Jelly advised he was not supposed to contact. Jelly provided Attard with screenshots of the initial call as well as 4 additional attempts using 6-7. So let me let you in on a secret as to what could happen here, Mr. Schiller. Right now, this 50,000, 10% bond that somebody posted, who's Jason Schiller?
My brother, Your Honor.
He could be eating that 50,000, 10%. I could revoke that bond. I could forfeit the bond, revoke the release, and set 100,000 cash and make you come in here and surrender yourself to the court. And then, just then, we might get around to handling the case when everybody else feels like handling it. So I don't know if you are not inclined to listen to judges' bond conditions, or you're in the habit of ignoring judges' orders. I'd do a 360 pronto right now if I was you.
Okay, Your Honor, yes.
Do you get what I'm saying to you?
I understand, Your Honor, yes.
Because I'm telling you, I do not tolerate that. It's no contact. You can't write, phone, see, text, email, communicate with her, drive by her house, write her, email, have anybody else do any of those things for you on your behalf. You do it again, you will live to regret it, trust me. How long were you in the county jail?
Long enough, Your Honor.
How long is long enough?
A few days, that's it.
You could be going back there in the next 45 minutes. Mr. Schulman, talk to your client. Tell him not to do that again, or we're going to have a massive problem here.
Very good.
You understand what I'm saying, Mr. Schiller?
I do, Your Honor.
Thank you, Judge.
Thank you very much. Have a good day. Thank you.
All right. All right. That is it. The video's over. You don't have to go home. You got to get out of here. Why did I say that? I don't know. Words are fun. They're also hard. All right. Let's see. Thanks for hanging out, guys. I appreciate it. Thank you for the super chats, the membership milestones. I do appreciate it. Again, sorry for the internet. My appointment's on Thursday, so we'll see if that happens again on Thursday. Yeah, I don't know what's going on with my internet. It's weird because it's at 8:30 every night. It used to happen right at 9 a.m. where my internet would just drop for about 5 minutes. Every morning at 9 a.m. it would happen, and then it just stopped doing it. And now apparently it's happening at 8:30. They just pick a block, and it's the exact same time for a couple weeks. So I don't anticipate it's going to stop tomorrow, which sucks. Anyways, you guys are awesome. Thank you for hanging out. I got it set up to raid Lone Wolf, so we're gonna go hang out with Lone Wolf. Yeah, that's it. That's all I got. I was gonna say, do you guys want to hang out on Discord, but I actually have to work on a video for tomorrow, so I'm not. I actually have to do work right now, so I'm not gonna be hanging out on Discord. So we'll do Discord maybe tomorrow night. Okay, you guys are awesome. Go tell Lone Wolf I said hi, and I'll see you tomorrow. Until next time, bye.
Thank you, Your Honor.
Hey, Judge.
Oh, I caught it. I caught it. Thanks, Otto. I appreciate it. Old tricks. You tried. You tried. Thanks, bud. I appreciate it.